The right to privacy has been one of the most important and one of the most controversial rights since the Supreme Court posited its existence in 1965 in the case Griswold versus Connecticut. In that case, the majority of 7 Supreme Court justices decided that in fact the right to privacy, most likely just the right to marital privacy, existed. In this particular case, there was no majority opinion. There was only a majority decision. When the Supreme Court decides cases, it has to get at least the majority to make a decision. So you have 5-4, 6-3, 9-0. All of these are decisions. If there is a tie, for example, if it's 4-4, sometimes you do have a tie because one justice recuses himself or herself due to conflict of interest. If there's a tie, then the decision of the lower court stands. So clearly there's a majority here because 7 is a majority out of 9. However, the Supreme Court not only decides cases but gives legal explanations for its decisions. And in this case, there's clearly a majority decision, but not a majority opinion. There's a plurality opinion. Plurality means more than anyone else, but less than a majority. So less than a majority of 5 here joined the plurality opinion written by Justice William O. Douglas. And the opinion is a very interesting opinion, and it doesn't quite make clear what kind of right to privacy was established, the right to marital privacy only, or the right to more general privacy. Now, the plurality opinion stated that the right to privacy is not really based on any one specific provision of the Constitution. That's already a red flag. Not based on any one specific provision of the Constitution, but on the collection of amendments considered together as a group, specifically amendments 1, 3, 4, and 5. Justice Douglas wrote, specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. So let me try to explain what this means. Justice Douglas was a creative person who wrote a lot of books and articles, and he decided in this particular case that you could not rely on any one constitutional provision to say that the right to privacy exists. First of all, there's no word privacy in the Constitution, and therefore no phrase, the right to privacy. So how did he arrive to the conclusion that a right to privacy or anything else can exist if it's not even mentioned? Well, he says, look at the First Amendment. The First Amendment does not have the words about freedom of association, yet the Supreme Court had concluded that freedom of association is implied in other guarantees inherent that are, in fact, expressly listed in the First Amendment. So he says, well, that's already should be a clue that a right might still exist, even though it's not specifically listed. And then he goes on to say that if you look at the First Amendment, what does it protect? Well, among other things, it protects freedom of association, that very freedom that is not specifically listed, but that the court had previously said is implied. If you look at the Third Amendment, it protects people from soldiers being stationed in their house in times of peace without their consent. The Fourth Amendment specifically protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the Fifth Amendment protects you from having to be a witness against yourself, or more colloquially, from having to incriminate yourself. Now, Douglas argued that if you look at all of these amendments, First, Third, Fourth, and Fifth, what they in fact protect is an implied separation between you as a person and the rest of society. And while the government certainly has to be able to regulate society, there is an area of separation, there's an area of exclusion between you, that is that which is proper to you as an individual, and the rest of the world. And based on the totality of these amendments, Douglas concluded that the right to privacy exists. And then he also says, almost as a parenthetical thought, as an afterthought, and by the way, the Ninth Amendment that argues that the rights that are not listed might still exist gives credence to this idea that, in fact, there is an implied right to privacy. But where specifically is it found? It is found, according to Douglas, in the totality of these amendments, first, third, fourth, and fifth. It's interesting that before he began this argument, Justice Douglas summarized the facts of the case, and then he said the arguments by some lawyers in the case imply that Lochner versus New York should be our guide, but we reject that invitation. Very interesting way to begin his reasoning. Why would he say this? Why would he try to argue that he was not trying to Lochnerize? Remember, if you listened to a previous lecture about property rights, and specifically about the case Lochner versus New York, you know that to Lochnerize means to invent the law instead of interpret one. Judges are supposed to interpret the laws, not to invent them. Why would a judge assert that he is not, in fact, inventing the law? That might suggest that he himself is at least worried that what he's doing is inventing the law, inventing a constitutional right that in fact isn't there. Now, there was a concurring opinion by Justice Arthur Goldberg in this case, and Goldberg argued that you don't need to do all this complicated song and dance about the right to privacy being somehow implied in the totality of the text of the First, Third, Fourth, and Fifth Amendments. All you have to have, said Goldberg, is the Ninth Amendment. Now let's look at the Ninth Amendment. The Ninth Amendment says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." In other words, just because a right isn't listed doesn't mean it doesn't exist. And then Goldberg went on to say, well, what does this mean? Which rights are there that might still exist despite them not being listed? He said, well, you have to go back to our constitutional history. Look at the constitutions of various states. Look at the statutory laws of various states. Look at the federal laws. What kind of rights do they protect? And Goldberg says, well, one particular right that they protect is the right to privacy. Therefore, all you have to have is the Ninth Amendment. You do not need to have any other constitutional provisions to establish that the right to privacy indeed exists. Now, Goldberg's opinion failed to gain traction, and there is no jurisprudence that stems entirely from the Ninth Amendment. That's why we call the Ninth Amendment a dead amendment, because there are no cases that are based exclusively on the Ninth Amendment. Why is this the case? Because if Goldberg's opinion took hold, then judges could go willy-nilly invent new rights. Suppose someone says tomorrow that there is a right to higher education. Well, because it's easier to find a job and you can live a life of better dignity and better conditions if you have higher education. Suppose someone says that. And let's say the day after tomorrow, someone else says, well, there is also a right to food and shelter and water or whatever. So if you rely on the Ninth Amendment as your sole guide to decide cases, you become untethered from the actual text of the rest of the Constitution, and you can substitute your own judgment for actual provisions of the Constitution. It leads to this circular argument. Some rights exist even though they're not listed, but if judges can substitute their judgment for the rights that are not listed, they can invent new rights, and that doesn't fly. And for this reason, the Ninth Amendment is actually a dead amendment. Now, I mentioned that Griswold versus Connecticut left a little bit open this question as to what kind of right to privacy was specifically established, because in Griswold, The law that was challenged was Connecticut state law, which prohibited the sale or counseling or instruction pertaining to contraceptives to married couples. And Estelle Griswold, who was the head of the Planned Parenthood League in Connecticut, and a doctor who worked at her office, in fact, engaged in just that. They provided prescriptions, counseling, and information about various forms of contraceptives to married couples. So the case involved married couples, but the opinion written in Griswold starts out by talking in general terms about privacy, and only at the end of the opinion kind of brings it back to specifically marital privacy. So there needed to be a resolution as to what kind of privacy actually exists. Is this a right that is reserved to married couples only, or is this the right that every person has? And Eisenstadt versus Baird answered that question in 1972. It extended Griswold's decision unambiguously to unmarried people, based on the Equal Protection Clause of the 14th Amendment. So Justice Brennan wrote for the majority of the court, if the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into the matters so fundamentally affecting a person as the decision to whether to bear or beget a child. So that was that. Everyone has the right to privacy. We are clear. But the court was not done yet. Privacy, you see, is a philosophically very amorphous concept. What does it really mean? And if it's philosophically amorphous, you can understand that it's also going to be legally amorphous or ambiguous. Exactly what is privacy? And the court, as time went by, determined that in fact privacy means that there are different distinct zones of privacy, like reproductive privacy, family privacy, parental privacy. Let's look at some of the cases. Roe versus Wade is the most famous case and the most controversial case of the last 40 years or so. In fact, much of the Supreme Court controversy surrounded abortion rights between, let's say, 1973 and 2003. Those 30 years were intensely focused on the question of abortion. In Roe versus Wade, the Supreme Court posited that there is a fundamental right to reproductive privacy, which includes the right to have an abortion. But the Supreme Court also said that this right is not absolute, because the state has a compelling purpose to protect the life of the pregnant woman and the potential life of the fetus. For this reason, the Supreme Court established a trimester-based framework. So during the first trimester of pregnancy, women had an absolute right to get an abortion, regardless of anything else anyone else said. During the second trimester, the state could regulate an abortion, but it could not outlaw it. If a woman wanted to get an abortion, she could. And the state, however, could require by law that a woman has medical consultation and that a doctor explain alternatives to abortion. So during the second trimester, there could be regulation of an abortion. And during the third trimester, if the court wanted to do so, if the state law wanted to do so, it could outlaw abortion altogether. It didn't have to do so. But if it wanted to, a state could in fact outlaw abortion altogether during the last trimester. Why did the Supreme Court come up with this framework? It wasn't random. The reason why was based on fetal viability. The Supreme Court said, and also on the safety of the procedure. When is the fetus likely to be viable, to exist outside the womb, to live outside the womb? The Supreme Court said, well, definitely not during the first trimester. During the first trimester, the fetus cannot survive outside the womb. The Supreme Court has also asked itself, when is this procedure safe? The Supreme Court said, well, during the first trimester, it's definitely safe. And then as it gets closer to birth, it becomes less and less safe. So during the last trimester, it's certainly not particularly safe. So the Supreme Court said, that's why we established this framework. However, we know what happened. As medical technology improved, fetal viability was pushed closer and closer to the point of conception. And also, as medical technology improved, it became safer and safer to have an abortion closer and closer to the last days of pregnancy. And for this reason, as Justice Sandra Day O'Connor put it in 1992, in Casey versus Planned Parenthood, Roe versus Wade is on a collision with itself. However, there still remains current law. This framework and the court's decision remains law. And of course, it produced a lot of controversy, and the country is about just as divided today as it was in the 1970s. More than 40 years have gone by, but the public opinion on the issue of abortion hasn't changed very much. There's also family privacy. I'll give just one case here. Moore versus City of East Cleveland was an interesting case when grandmother and two of her grandchildren, who were not brother and sister, but they were cousins, they were first cousins, lived in the same dwelling unit together, which was against the ordinance passed by the City of East Cleveland. East Cleveland defined a family as a nuclear family, a parent or parents and children. And so clearly grandma and two grandkids fell out of the definition of a family, and they could not live in the same dwelling. The Supreme Court, by a 5-4 decision, said that the City of East Cleveland has overstepped its boundaries, that family privacy protected grandmother and her children. It's interesting to note why the City of East Cleveland passed this ordinance in the first place. The reason why is because a number of people from the City of Cleveland sent their kids to live with with other relatives, away from parents, with other relatives in East Cleveland, so that they could attend better East Cleveland schools. The City of East Cleveland didn't want this, and so they tried to gentrify the city. Also, there were too many cars on the streets because parents would come to visit. So they said, well, there are too many cars on the streets. There are too many kids in school. And that's why they passed this ordinance in order to gentrify the city. However, the Supreme Court shut it down. And that's an example of family privacy. Parental privacy, let's look at a couple of cases. Michael H. versus Gerald D., a very interesting case out of California. California had a law that said if you want to claim paternity, but you are not the father who is listed on the birth certificate, you've got exactly 2 years to claim paternity. And if you miss your 2 years, you miss it forever. You can never again have parental rights under the law of the state of California to this particular child. And Michael H. claimed that he was in fact the real father of a baby girl who was born to his mistress Victoria D., and not Gerald D., who was actually on the birth certificate, because he claimed that he had an out-of-wedlock adulterous affair with Victoria D., or rather Victoria D. had an adulterous affair with him, with Michael H. But the thing is that while his paternity was biologically established, he missed his 2-year window. And the state of California denied him paternal rights. So he sued. This case went all the way to the Supreme Court. The decision was 5-4 in favor of Gerald D. The Supreme Court, speaking through Justice Scalia, said that while paternal privacy rights exist, Michael H. loses this case because the state has a compelling purpose in protecting the stability of the family. Why is this a compelling purpose? Because the stability of society itself is based on the stability of the family. Imagine if anyone at any time could claim paternal rights against any child. This would create too much instability. And therefore, Michael H., even though he has parental rights, he has forfeited them because the state's compelling interest overrode them. He waited too long. The state of California acted using its compelling interest and using narrowly tailored means to carry out that interest. Troxell versus Granville, in this particular case, Brett Granville committed suicide, and Tommy Troxell was left with 2 children alone as a single mother to raise the children after the father committed suicide. Brett Granville's grandparents wanted greater visitation rights than the mother allowed them, and so they persuaded the state legislature to change the law that would allow anyone to claim visitation rights if they could demonstrate that visitation with them would benefit the child. So this law was passed, and Troxell sued after the grandparents got greater visitation rights, saying that this law is unconstitutional because it violates her parental privacy rights. The Supreme Court agreed with the mother of the children in this case, claiming that a law that gives visitation rights to anyone based on the child benefit theory was too broad and violates parental rights. Marital privacy and sexual privacy are quite interesting cases. Let me start with marital privacy first. Lavin versus Virginia, 1967. Prior to this case, a number of states still prohibited marriage between people of different races. In most states, there were about 12 or 13 before this case that still prohibited marriage across racial lines. The law was typically written to say that whites could not marry across racial lines. And in Lavin versus Virginia, the Supreme Court decided that all such laws were in fact unconstitutional because they violated 2 provisions of the Constitution simultaneously. First, the marital right to privacy, and second, the Equal Protection Clause of the 14th Amendment. So it took actually a long time in American history to abolish all restrictions to marriage across racial lines. And it took even longer to guarantee the right of homosexuals to marry. That was done only in 2015 in the case of Obergefell versus Hodges, when the Supreme Court, in a very narrow decision, 5-4, found that limiting marriage to a man and a woman violated the Equal Protection Clause and violated the marital right to privacy of homosexuals. Sexual privacy is a different zone of privacy than marital privacy. Sexual privacy cases in this country pertained to homosexual relations. In Bowers versus Hardwick, the Supreme Court, by a 5-4 decision, refused to rule for Michael Hardwick, who was arrested and charged with homosexual sodomy in the state of Georgia. He was not prosecuted, however, he was arrested for it and initially charged with it. And even though he was not prosecuted and not sentenced to any fine or prison for that act, he still was allowed to sue, and he named prosecutor Bowers as a defendant in this case. So in this particular case, the deciding vote was actually that of Justice Lewis Powell, who initially wanted to take Hardwick's side, but eventually switched his position. And many years later, after Justice Powell had retired, he would go on to the lecture circuit, and he would make appearances at various universities. And he spoke at one of the universities in New York in response to a question if he ever regretted any decision that he made. he said, well, no, not really, but if I had to pick one, it would be Bowers versus Hardwick. If I had to rule on this case today, I would rule differently. But back then, I didn't even think the case was important, and in fact, I was annoyed that I even had to hear it. So we see here that it matters who sits on the Supreme Court. Justices are not indifferent. Justices do not operate simply mechanically based on law. They also operate based on their own perceptions and views that are kind of colored by preconceptions and prejudices. Lawrence versus Texas overturned Bowers versus Hardwick. In Lawrence versus Texas, after a false weapons disturbance, the police was called into the apartment of Lawrence and Garner, and Lawrence and Garner were charged with homosexual sodomy, and they appealed this based on the idea that the right to privacy protected sexual privacy. So what happened? Well, almost 2 decades have passed since Bowers versus Hardwick, and the Supreme Court changed its mind. There has been a change of guard. Some justices have retired. New ones came in. In this particular case, the Supreme Court found, based on the sexual right to privacy, that Texas's law and other states' laws that criminalized homosexual sodomy were in fact unconstitutional. It's interesting to note that the decision in Lawrence versus Texas had a significant political fallout. After this decision, many states began to pass constitutional amendments to their own state constitutions that defined marriage as between one man and one woman. And this process lasted actually for quite some time. Some spilled well over after the 2004 election. Even as recently as 2008, the state of California passed Proposition 8 that amended its constitution to say that marriage could only take place between one man and one woman. And it's interesting that this decision in Lawrence versus Texas mobilized a lot of conservative voters and helped George W. Bush win re-election in 2004, even though I believe that looking at the numbers, he would have won that election one way or the other. He would have edged out his opponent, John Kerry. But nevertheless, Lawrence versus Texas helped to mobilize conservative public opinion and helped to get conservatives to the polls and win election for George W. Bush. Thanks.